At what point did your office actually get involved in this process?
Within the last couple of weeks, we met here at the office with the attorneys hired by the governor and a couple of members of the governor's team, including his chief of staff and legal counsel. And we discussed, really a significant point of law, which is that the Attorney General has to control all litigation brought on behalf of the people of the state. There are some exceptions. So, for example, what we call quasi-public agencies, think the airport, the Rhode Island Turnpike and Bridge Authority, not so much there. But when you're bringing a lawsuit on behalf of the people, the state itself, my office has to do that and has to control that litigation. We don't work for the governor. That's, I think, obvious to many, maybe not to all. We are a separate, I am a separate constitutional officer. And what I'm charged with doing is bringing lawsuits on behalf of the people. And so were we not to be involved, that posed risk for any case that might be brought. And so I think when counsel hired by the governor got to the point where they felt like a case was likely, I think that concept, crystallized for them. We had always been somewhat concerned, but look, I had reached out to the governor very shortly after the bridge had to be closed and offered our help. And so we were waiting to see exactly what direction they took. Pretty clear now that they at least believe that there was a potential case there. But truth is, it can't be brought without my approval and without us making sure that it is in the best interest of the people of the state. When what that means in this context is it what we would call a well-pled case, meaning is it a case where the allegations are credible and strong, and is there a potential of success on behalf of the people of the state? I've assigned 2 excellent lawyers to it, leaders in the office in our civil division and our public protection bureau, including the deputy chief of the civil division, Sarah Rice. And so I'm confident that the team, along with Mr. Savage and Mr. Wistow, will be well positioned to protect the taxpayers' interest.
Do you think you should have been involved in this sooner?
Well, look, I don't think that there's any downside to being involved sooner, but there hasn't been, and there won't be, an ill effect from that. Our lawyers, particularly the ones I've assigned, are used to getting up to speed in cases quickly. They're responsible for some of the more significant cases the office has brought in my administration. They've argued some of the most significant cases that have had to be argued on behalf of the people of the state. So there's no question that to the extent they need to be ready to go, that they will be.
You had mentioned you offered pretty early on to get involved, and I guess you weren't taken up on that offer. If that had happened, would you have liked to have been involved in the hiring process of outside counsel, or was it even necessary to hire outside counsel?
Yeah, I think, look, we've hired outside counsel ourselves for certain kinds of litigation that we've brought, usually ones where the resource challenges are going to be great. I only have 30 lawyers in our civil division that are representing, about half of them do nothing other than representing the state when the state gets sued, and the state gets sued pretty regularly. The others do healthcare, energy, the environment, consumer protection. And so while I could assign 2 lawyers to the case, you would certainly need support staff help and more. And so I think we would have hired outside counsel even if we were sort of running things from the beginning the way we are now. But certainly Mr. Savage and Mr. Wistow are very accomplished lawyers, and there's no question that our lawyers will work well with them. And again, as long as we are directing the litigation, which everyone agrees we will be, then we'll be in a good place on behalf of the taxpayers.
Has this had any impact on how quickly we're able to bring forth litigation?
No, not at all. I mean, again, the lawyers here can get up to speed very quickly. And of course, we have the benefit of Mr. Savage and Mr. Wistow's work to date, and so that makes it, of course, a lot easier than simply starting from scratch.
They had said they expected a lawsuit to be filed on or before August 19th, which is Monday. Now that you're saying you're in charge of whether or not that happens, what do you see as the timeline?
Look, I think that timeline is likely to hold for a variety of reasons, and But look, I think one thing that I want to be sure of, and I'm not there just yet, is that we are in a position to bring a well-pled case, and I'm still reviewing things myself, and until I reach the point where I'm comfortable and the team around me is comfortable advising me that we're in the right place, then I'm not going to be in a position to say much more than I already have.
Is there anything in particular holding you back, or you just need to go through more materials?
No, I think it's just a matter of spending time with what the findings have been to date. There's a lot of information, frankly, we don't know yet. That information, I think, will come out over time if a lawsuit is brought. So, look, when you bring a lawsuit like this, it's not like a criminal case where you know everything when you go into it, or even some civil cases where you've taken discovery before a matter starts. So think about a consumer protection case, like the one we've been talking about, where we're able to take discovery, get information from potential opposing parties before we even bring a complaint. We have that authority under what's called the Deceptive Trade Practices Act, which we fought for to get in the second year of my administration. We only have that in certain contexts, consumer protection being one of them, healthcare is another, but we don't have it for things like negligence and breach of contract. So there, our obligation is to bring what's called a notice pleading, which is to put the other side on notice of what we believe happened, and then the case tends to get fleshed out from there in terms of who all the parties are or aren't, and exactly what claims fit the best. So there's, even after a complaint would be filed, there will still be a time where that case will begin to shape itself, but that tends to happen over months and not days.
The governor had referenced several months ago a day of reckoning. Do you think that is when the complaint is filed, or if more information is going to come out over time after a complaint is filed? Is that kind of when something's settled?
I'm not quite sure what the governor meant by that. I if I'm speculating, which is always dangerous, it was that it would be at the point where somebody who was responsible for causing the bridge to be at a point where it had to be closed so precipitously would be held accountable for that. Whether that meant people working for the state, whether that meant outside entities, I'm not sure what he meant. He may not even have known at that point what he meant because it wasn't clear yet who is truly responsible. I think those are things that will come out over time. But I will say, certainly the filing of a complaint, if there is a complaint filed, will obviously, I think, be the beginning of the state seeking to hold people responsible for leading us to a point where we had to close a bridge at really a moment's notice. And that's obviously not the way infrastructure issues should be handled. And of course, it's had a significant impact on the residents of Rhode Island, including local businesses that have really been hurt by this.
Do you have an idea? Is it one person or entity or multiple that would be the subject of a complaint?
Yeah, Gabrielle, I really can't say at this point.
Are you able to indicate, would it be like state or federal filing for this type of complaint?
I really can't.
The other lawyers had said they had an idea of what happened. You would agree that there's at least a general idea of what went wrong?
Yeah, look, I think that's right. I think that, again, if you go back to what this bridge, when it was originally built, the governor and his team have stated this publicly before. The design is an unusual one, and so the question becomes, over time, should there have been actions taken by someone working for the state or not working for the state that should have identified, when you come to a fork in a road, should we do this or should we do that? Should we try to do anything at all at this point? Should we be planning for a new bridge, given where we are in terms of the lifespan of this particular bridge? And so that's, that I think are the questions which have to be asked in a vacuum, and are the questions which may or may not, depending on what the answers to those questions are, or what you think the answer to those questions are, lead you to litigation or lead you not to bring a lawsuit.
You mentioned either somebody within the state or outside of the state. Would the state file a lawsuit against somebody working for the state?
No. I mean, I think the question becomes, is the state agency charged with maintaining and hiring people to maintain and build our infrastructure? is there somebody there who should have taken a particular action? I mean, the state would not sue itself, but certainly it does factor into who's ultimately responsible. And look, there are scenarios where an outside actor could be responsible, notwithstanding what a particular state actor did. So those are all the things that go into analyzing the path forward, and that work's been done by Mr. Savage and Mr. Wistow, and we're doing it now with them as well, and that's something that I really need to get a handle on and get my head around in the relatively near future.
As you do that, are you speaking with the governor? Are you speaking with these other lawyers? Who's involved in that process?
Yeah, there's really no reason to speak with the governor. I mean, he's not part of the litigation team. I mean, the relationship is between this office and Mr. Wistow and Mr. Savage, and I have had conversations with them as recently as last week. But going forward, certainly I will have conversations with them where there are decision points where significant decision points for certain, and other decision points where there is not agreement among the line lawyers as to what we should do. At the end of the day, if someone has to make that decision, it'll be me in the end, and I have to affirm any significant move forward, and I'm going to be prepared to do that.
That's 100% up to you, not the governor, not any
That's correct. The only parties that effectively matter legally are this office and Mr. Wistow and Mr. Savage, because they are the outside counsel that have now been retained by this office. That is what our most recent agreement provides. Now, certainly the governor will be kept in the loop. I mean, it's his agency, after all, that was responsible for maintaining the bridge and ensuring that the infrastructure was what it should have been. And so obviously that's one of his agencies, and this is litigation, which no doubt is important to him. And so, I have committed to keeping him and his team in the loop. But at the end of the day, the relationship that really matters for purposes of the litigation, which is all I care about. The only thing I care about is the litigation is between this office and outside counsel. I mean, it could have been Mr. Wistow and Mr. Savage, it could have been somebody else. But even that choice is ours. And in this particular instance, we've chosen to continue to work with Mr. Savage and Mr. Wistow. Certainly they are capable, accomplished, experienced lawyers. And that relationship is very, very good. But if for whatever reason it wasn't, then we could have chosen different outside counsel, even at this late stage.
Is there anything else you want to add or you can add?
Not that I can think of. It's good to talk to you.